Good evening, I am Advocate Dadhich practicing before Rajasthan High Court. Every day our court decides hundreds of cases. Most of these judgments resolve a dispute between the parties, and that's where mostly the battle ends. Every now and then, a judgment comes along that way that reminds why criminal law exists in the very first place. Today's judgment is one of those. The case is of Sonu Ram Pachauri vs. State of Rajasthan, decided by Honorable Rajasthan High Court. Now the legal question before the court was very simple to state, but the answer carries enormous constitutional significance. The question was, can a criminal trial continue against a person who is mentally incapable of understanding the proceeding that has been taken against him? Not whether he has committed the offence, not whether the prosecution has enough evidence. Can the law put someone on trial if he cannot even understand that is being tried for? To answer this question, we first need to understand the facts of this case. The prosecution arose out of a murder case. The alleged offence has taken place decades earlier. For many years, the accused remained untraceable. By the time he was finally arrested, he was an elderly man suffering from severe dementia. His son approached the trial court with medical reports and psychiatric records. The case put forward by the family was straightforward. The accused was no longer capable of understanding the proceedings. He could not understand the charge against him. He could not follow what was happening inside the court. Perhaps the most importantly, he could not meaningfully instruct his advocate who is appearing for him in the trial court. Now think about that for a moment. If a person cannot even tell his lawyer what happened, how can that lawyer effectively defend him in the court of law? That is exactly the concern before the trial court. After examining the medical material placed before it, the trial court decided to postpone the proceedings. The accused was allowed to remain in the care of his son. At the same time, the court directed that the medical condition be reviewed periodically. The matter, however, did not end there. The victim challenged this order before Rajasthan High Court. The argument was that the trial should continue and that the trial court has acted prematurely in this case. This is where the real legal conflict emerged. On one side, the victim's legitimate expectation that criminal trial should reach its conclusion. On the other hand, the accused's constitutional right to a fair trial was at stake. So how does the law resolve this conflict? Before looking at the judgment itself, there is one legal distinction that is absolutely essential to understand. And in my experience, this is where most people get confused. The law asks two completely different questions. First question is medical. Is the accused suffering from any medical condition? Doctors answer that. The second question is legal. Does the condition prevent the accused from understanding the proceedings and defending himself? Only the court can answer that. These are not the same question. A diagnosis of dementia or Alzheimer's disease does not automatically stop a criminal trial. The law is not concerned about merely with the label of a medical problem. It is concerned with the accused's functional capacity to understand things. Can he understand the accusation? Can he follow the evidence? Can he communicate with his lawyer? Can he participate in his own defense? If the answer is yes, the trial continues. If the answer is no, the law has to step in. And that brings us to what? In my view, this is the most important part of the judgment. The court reminded us that Article 21 does not merely require procedure established by law. Ever since the Supreme Court decision in the Menka Gandhi vs. Union of India, that procedure must also be fair and reasonable. A criminal trial is not simply about bringing an accused into a courtroom. A fair trial requires meaningful participation. If an accused cannot understand the evidence, cannot understand the charge, cannot understand why the witnesses are being examined, then his physical presence inside the courtroom becomes nothing more than a formality. And the constitutional democracy cannot be satisfied with these mere formalities. Therefore, this judgment has held that where credible recent medical evidence established that the accused lacks capacity to understand the criminal trial, the trial is fully justified in postponing the proceedings. We have to notice that what court has done there. The court is not creating an exception for persons suffering from dementia, nor it is saying that such accused can never be tried. The court is protecting something larger, the integrity of the criminal trial itself. Because the purpose of a criminal trial is not merely to reach to a verdict. It is to reach that verdict through a process that is fundamentally fair. Now, from a practical perspective, this judgment is equally important. Sometimes people assume that postponing a criminal trial means the accused has escaped prosecution. This is not what the law says. The proceedings are only suspended. They are not terminated. If an accused regains the mental capacity to understand the proceeding, the trial ought to continue. If the medical condition remains unchanged, the court continues to monitor the situation to periodic medical assessment. In other words, the criminal justice system does not abandon accountability. It simply refuses to sacrifice fairness in the pursuit of accountability. And I think that this is the real contribution of this judgment. Not because it changes the law dramatically, but because it reminds us of something we often overlook. The Constitution does not protect merely from wrongful conviction. It also protects us from unfair process. Because once the process itself becomes unfair, justice slowly begins to resemble power. And that is something our constitutional courts have consistently refused to accept. Thank you for watching. If you have read this judgment differently, or if you think there is another Supreme Court decision that strengthens or even challenges this, I would be genuinely like to hear your perspective. These discussions are valuable because law evolves through a careful debate, not just conclusions. I'll leave the full judgment and the key statutory provision in the description, so you can read them by yourself. Thank you, and I'll see you in the next analysis.